All right, I'm going to close the executive session on SB 459 and open the hearing on SB 464, and the chair recognizes Representative Kutab to introduce the bill.
Good morning, fellow members of the Judiciary Committee. For the record, I'm Representative Caitlin Kutab, and I'm introducing Senate Bill 464, which is relative to civil rights enforcement. The prime sponsor will be up here in a little bit and will be able to further speak to the bill. So I will not be taking any questions. Thanks so much.
Thank you. All right, next I'm going to call on Bonnie Bruno, please.
I'm like the opening act. I oppose SB 464 along with at least 320 other granted states that signed in and as well as people on the blue sheets in the majority. This legislation changes the standard for civil rights enforcement by requiring that prohibited conduct be substantially motivated by hostility toward a protected class. That is not a clarification in the law, it's a narrowing. So I have to ask myself, what is the purpose of making it harder to protect people in the state? SB 464 raises the burden of proof from demonstrating harm to proving intent, and not just intent, but a specific level of hostility. In the real world, civil rights violations don't present through explicit or provable hostility. It often appears through patterns, decisions, and outcomes. This bill narrows the definition of what counts as a civil rights violation and makes those cases harder to prove. These matters are best weighed by the courts based on facts in each individual case and not preemptively narrowed in statute. I urge you to ITL this bill, please.
All right, questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Sean Locke, please. Oh,
Still morning. Good morning. Chair Lynn, members of the House Judiciary Committee, I'm Senior Assistant Attorney General Sean Locke here on behalf of the Department of Justice to oppose SB 464. And I think before I begin, I know it hasn't been introduced yet, but I have comments about the amendment.
Yeah, no, I was going to ask you about it for sure.
Okay. And also speaking to the amendment, we would also oppose the proposed amendment. So in short, SB 464, including the proposed amendment, takes New Hampshire in the wrong direction, with the amendment taking us a little bit further. The bill reduces the already limited protections afforded to protect the public's civil rights from hate or bias, motivated or prejudice, violence, property damage, threats, and trespass. I would note, too, that the Senate Judiciary, before passing it on to this chamber, their committee voted 5-0 to interim study the original legislation. But data from NIBRS, our office, and the Anti-Defamation League all report increasing incidents of hate, bias, or prejudice behavior. From NIBRS, it has increased from 17 potential hate crimes in 2019 to 43 in 2025. The department, my unit, has seen an increase in complaints from about 80 per year in 2019 to over 225 last year. Nationwide, the Anti-Defamation League has reported year-over-year increases in anti-Semitic incidents from 2014 to 2024, with massive increases in 2023 and 2024, increases on the order of magnitude of thousands of incidents. And again, that's nationwide data. So given this data, the department's position would be we should be having a different conversation about how to modernize and expand civil rights laws, such as RSA Chapter 354B, to better protect those who have experienced unlawful acts motivated by hate, bias, or prejudice. As written, it appears that this is a solution looking for a problem and risks turning in New Hampshire into a safe harbor for anti-Semites, racists, and homophobes and others who deal in hate, because we will have the weakest civil rights laws among states north and east of West Virginia and Indiana. Now, let's discuss what this bill does, because I've heard it described at times, at least in the introduction in the Senate, as clarifying the statute and how it does more than just clarify. In preparing this testimony, I have considered laws across all 50 states. In looking at this, I've canvassed all 50 states to look for similar civil rights laws, and kind of will draw some comparisons between them. First, it adds the phrase kind of substantially to motivated by, so it becomes substantially motivated by. This creates uncertainty about the quantity of motivation necessary to prove the violation has occurred. In my canvass, I found one other state with a similar requirement in its laws, Most states use language such as motivated by, because of, or motivated in whole or in part by, to define the necessary motivation required to prove a hate-motivated act. The uncertainty or confusion arises when you start modifying terms with adjectives and adverbs. Now, some might say this only draws from the hate crime sentencing enhancement that already exists in state law. What's the problem? Well, there's a recent example out of the Hillsborough County Superior Court's Northern District where there was an assault that occurred. It was a bench trial, so we actually have good insight into why this was a concern. It was a same-sex couple walking down Elm Street. They were followed and heckled by an individual, called homophobic slurs, and had homophobic remarks made at them. When they turned and they didn't engage in any act of violence, they turned to confront these individuals, to tell them to leave them alone, and they were assaulted. They were acquitted of a hate crime. The suspects in that case were acquitted of a hate crime because the judge wasn't certain what quantity of motivation was necessary to prove the hate crime had occurred. And unfortunately, we couldn't appeal that decision because it was done after jeopardy had attached. Second, this would require proof of hostility. Now, when we look at any case, when we're looking at cases and deciding whether or not to bring them, we're looking for some evidence of discriminatory animus, hostility, bias, or prejudice. The concern with saying hostility, and this came up during the Senate Judiciary Committee hearing, is that the word hostility creates an image in a person's mind of what is expected to prove hostility. It creates almost a requirement or an expectation that there's kind of long-term hatred directed at the target of the act here. And I think that is under-inclusive. And there was Senator Abbas and I had a protracted back and forth about what would be a better word. I've had an opportunity to kind of consider that. And we think there might be better, you could say something like hostility or animus, including hostility, prejudice, or bias, to kind of capture those different ways that hostility can manifest. It may not always be virulent hatred. It may be prejudicial kind of conduct. And we have a recent example that we filed where prejudice was the factor. There was a shooting that occurred in where the victim was Black and the suspect was white. And I speak to what is kind of publicly available. I won't speak to anything beyond that. But the allegations are that kind of in the 911 call, when asked why the victim shot, or the suspect shot at the victim, she said, well, he was Black. And so, there wasn't necessarily evidence of hatred towards Black people by this person, but certainly there was prejudice behind the decision-making that led to attempted assault, attempted use of force, and certainly threatening behavior on part of the suspect. Now, the last piece here in the base bill talks about, drawing this nexus between the victim and the protected characteristics at play. We've had arguments that have gone to the New Hampshire Supreme Court where the ACLU and others have argued that this is a necessary requirement for the law, and the New Hampshire Supreme Court has not adopted those arguments. It's not a correct reading of this statute. It's not a correct reading of what the Constitution requires. Courts across the country in Illinois, Iowa, Maryland, Montana, New York, and in the federal courts have rejected those similar arguments that there needs to be a nexus between the victim and the protected characteristic. In states where courts have required some form of that discriminatory selection, that's a product of what the statute says it requires instead of what the Constitution or any other kind of principle of law requires. And we can, and that plays out in how our hate crime sentencing enhancement works versus the existing version of the Civil Rights Act. This hate crime sentencing enhancement requires substantial motivation based upon the victim's protected characteristics to commit the crime. The sentencing or the Civil Rights Act doesn't have that same nexus. There's that through line is lacking. And having that slightly broader scope to the Civil Rights Act is important to protecting people's rights. Looking at kind of states across the country, there are 28 states that have civil statutes similar to that address hate-motivated behavior. Of those 28, 17 lack that through line I've been describing. 10 requirement, and then the remaining, it's a little more ambiguous in terms of, because they include not just the victim, but anyone who is affiliated or associated with someone who holds a particular protected characteristic, which I think is a major distinction. So why is the through line something that we would oppose? As I said at the beginning, it diminishes the protections and creates these safe harbors. And I think there's kind of a historic example of how this can play out. If you think back to the civil rights movement in the 1950s and 60s, there were the Freedom Riders, individuals who traveled to the South to help advocate for civil rights for people of color and help register people to vote. Some of them were people of color themselves, others were white. Many, if not all, were victims of violence. And this Civil Rights Act, as it is currently written and as it exists in our law, would protect those individuals who are white because they're not being targeted because of their race. They're being targeted because of their affiliation and support and because of the hostility towards the rights of Black people. Even in contemporary examples, there are two instances that have occurred in New Hampshire where this has come into play. First, the old property at the Latonia State School that had been abandoned for a long period of time was a scene of multiple instances of anti-Semitic graffiti. If I think the state was still the owner of the property at the time, if there isn't, this was clearly targeting the Jewish community. It was motivated by hostility towards the Jewish community, but it wasn't the state doesn't have a religion, doesn't have a national origin. It couldn't be the victim of a hate crime in the same way. So we wouldn't be able to use the Civil Rights Act to address that type of misconduct. Another example where some of the incidents would be allowed under the proposed law and others wouldn't was a spree of vandalism that occurred almost 3 years ago now in Portsmouth, New Hampshire, where a person graffitied multiple businesses and locations, including Temple Israel, including the Episcopal Church in Portsmouth, with anti-Semitic and kind of racist graffiti. They targeted, a lot of the businesses that were targeted because they displayed pride flags or displayed kind of other symbols of being a welcoming and inclusive environment. Under the proposed legislation, all of those violations of the Civil Rights Act wouldn't be actionable because there wouldn't necessarily be evidence that they were targeted because of the owner's protected characteristics. They were targeted, though they were motivated by hostility towards protected characteristics of others. So I also want to speak a little bit to the amendments here. The only, in paragraph 1, I know there's kind of some rearranging of the language. They do largely the same things, I think, and Representative Lynn can speak to that better than what the base bill does. It just kind of reworks some of the language. The only major substantive change or addition is this imminence requirement in terms of inflicting harm on a person or a person's property, so in the threats definition. So both the New Hampshire Supreme Court and the United States Supreme Court define true threats to include expressions of a serious intent to commit unlawful violence against a specific individual or group. Neither require imminence to be evidence there. So the language here dealing with threats comes from the state's laws on criminal threatening, which have been recognized to withstand constitutional scrutiny. The only crime I am aware of for which there is an imminence requirement is necessary is usually incitement to violence or incitement to commit some other criminal act. We receive many complaints every year alleging threats or threatening conduct. And I have had countless conversations over 7 years about threats and the distinction between true threats and statements or behavior or conduct that is disturbing, frightening, and may make someone concerned for their safety. And we're often kind of advising people how to take steps to protect themselves in the public, protect themselves in their communities. One of the criticisms when I am having those conversations is what has to happen before we can do something to help a victim? Do they have to wait until they are the victim of violence? When is enough here? And so to add this imminence requirement only makes it harder for us to protect those individuals and entities, synagogues, churches, mosques, all kinds of entities are targets of threatening and harassing behavior. And if we have to wait until the threat is imminently upon them, we are limited in what we can do to protect them and keep those individuals away from that property, keep them away from that place. And I think that example of the vandalism in Portsmouth provides a good reason why, imminence could be a problem. In that case, we brought this case before even the criminal charges were filed because we knew who the suspect was and knew we had the ability to do so. We understood that this individual may have been targeting places that were supporters of the LGBTQ plus community. And in about 3 months after the incident occurred, Portsmouth hosts a major Pride Festival. And so there was concerns for the safety of those who would be attending that Pride Festival if this person was out in the community and unidentified. We also knew that this person may have access to guns. So we took action before the criminal case had been brought to get a restraining order in place and be able to protect the public from future harm. If we have to have an imminence requirement for any threatened behavior, we wouldn't be able to take those proactive steps. So I mentioned at the beginning, we should be having a different conversation. We should be looking at ways that we can expand civil rights laws. The Anti-Defamation League, they have a report card that includes some suggestions on how to better protect the Jewish community and all different communities within the state. They've suggested putting together a hate crime task force that can pull people from across all different disciplines and communities to assess our laws, resources, and develop improvements. New Hampshire is also one of 7 states that lacks a law specifically protecting houses of worship. It's a recommendation from them. Thinking about the Civil Rights Act, one of the more common instances where we have to decline assistance to people is usually in the form of harassment, which isn't covered in this statute, but is a criminal offense. Could there be a law, could there be an amendment here that incorporates harassment so we can better protect those who are being targeted with abusive behavior by phone, internet, or mail, and could benefit from these protections? So, as I've stated to other committees, our department is willing to work with stakeholders to develop legislation that protects the public. The current proposal diminishes those existing protections, and we cannot support it as is. We recommend that SB464 be ITL'd or interim studied to address these concerns, and I'm happy to take any questions.
All right. So I guess I have a question first, Mr. Locke. One of the things that I thought was particularly telling in Representative Abbas's testimony in the Senate was the example he gave, and I think it strikes me that it's spot on. And I think the example that he gave was going back to the Hood case in Portsmouth about the white supremacist group hanging the sign, I guess, on the screening over the bridge, saying New Hampshire's for white people only, or should be for white, whatever, some disgusting kind of remark. But if I understood what he was saying is, let's assume, and I know the Supreme Court disagreed with this, and I personally happen to think they were right, but let's assume that the state's position was correct and that you didn't have to have a knowing trespass on the property of the state, the screen over the bridge. Let's assume that that was the law. You didn't have to have a knowing trespass. What Representative Abbas said, and I think he said correctly, is that that would not only mean that the people who hung the sign could be enjoined under 354B, but that if I was driving by and I saw that there was a sign up there and I thought, my God, this is terribly racist, I'm taking this down, and I went to take it down and therefore trespassed, I too would have violated the statute because there is no requirement of hostility to a race. So, I mean, is he wrong? Couldn't the statute, the way it's now written, wouldn't my conduct also be a violation of the statute?
And that's why I say, and I said this during the testimony, I think my testimony to the Senate, I think the least of our concerns is the inclusion of hostility. The issue is, what is the scope of hostility, and does it capture everything that could be kind of prejudiced or biased against a particular group? For that concern, and that's why we look at them that way. So we don't kind of end up kind of policing speech. That's not the goal. The idea is to police unlawful acts that are motivated by animus.
Right, so whether you call it animus or hostility or whatever, I mean, it sounds to me like what you are really saying, and I don't for a minute dispute the good faith of the Attorney General's office, but what you really are saying is there's not a problem with the law because the way we would never bring a case against Lynn for taking down the racist sign. And I guess my response to that is, well, that's great. I'm glad you wouldn't, but the law shouldn't allow it at all.
But that's why I'm also saying we're willing to work with individuals around it, making improvements that can help with those types of interpretations of the law. This goes much further than that. If we were just talking about adding the word hostility, we would be having a very different conversation. We're talking about doing a lot more than that.
All right, well, so let me just ask you, when you say, I mean, I thought I carefully listened to your testimony in drafting this. And for example, where you say, you gave the example of what if somebody goes after somebody that is not, in other words, they go after a third party.
I talk about like the neighbors.
The neighbors.
Yes,
right.
yeah.
Sure. So this, I thought that the language that I used here saying that hostility towards the race, color, religion, national origin, ancestry, sexual orientation, sex, gender identity, or disability of the person who is the target of the aforementioned activity. So if I'm, gonna draw, swastikas on the house that's located across the street from the synagogue, but my purpose in doing that is to target the synagogue, I'm covered by this, am I not?
Well, so that's, I wish you had introduced this before I spoke on it, but I think, I don't read that same way. I think there, we could talk about, again, that would be language I would be happy to kind of try to work with you to address. Because I don't think I read it, and maybe it's just kind of the person who's the target of the aforesaid activity. What is the aforesaid activity? Because I read aforesaid activity to be the unlawful act. So like, again, in that example you gave, it would be the neighbor who has to be the holder of the protected characteristic as opposed to the synagogue. So I just, there might be ways to clarify that. That's the way I read it. And again, I've only looked at this for kind of, maybe about half a day. You've obviously thought a lot more about it, but that, is the way I kind of see it and read it. And, I think we could workshop something that could improve that.
Okay, all right. Other questions? Yes, Representative Birch and then Representative McFarland.
Thank you, Mr. Chair. And thank you, Attorney Locke, for rapidly speaking through a lot of law. I have a number of issues I'm trying to focus down. I'm looking at the amendment, and I want to discuss with you or raise a question with you about the First Amendment aspects of the amendment. And I'm looking specifically at the language, threaten conduct, which is words, declaration, which are words, and coerce, which is words. Would you agree, leaving aside the discussion you already did of true threats, and I assume you're thinking of Virginia versus Black and cases decided there under, would you agree that this language under NAACP versus Claiborne Hardware, where the Supreme Court said speech doesn't lose its protected character simply because it may coerce them into action, that the language here potentially criminalizes First Amendment protected rights?
So I wouldn't, and here's why. Because what's happening here is you still have to have the direct threat. So like you have a threat that's occurred that takes outside of the speech outside the protection of the First Amendment already. This adds an element of kind of there has to be in doing that a purpose to coerce or terrorize another when making that threatening comment. And so that's consistent with, I forget the RSA off the top of my head, but the criminal threatening statute in New Hampshire, there's a lot of use of that purpose to coerce or terrorize in certain contexts there, but it still has, you still have kind of the predicate. There has to be evidence of that direct or that true threat, that kind of unlawful criminal threat that has occurred. And it was made with that purpose to coerce or terrorize another. So it's not just kind of speech. And that's the distinction where it really focuses on, and I think this is the Counterman decision from a few years ago, the intent of the actor who is making the threat as opposed to the person who is the target or the recipient of the threatening conduct. It's more subjective on what the actor intends as opposed to what the recipient feels.
You know what, thank you. I'm just going to say, I see that Senator Abbas has returned, and I wonder if I could just, Senator Abbas, do you have, obviously you're the prime sponsor of the bill, and we want to hear from you. Do you have somewhere else you need to be? I mean, are you under a time constraint? All right, fine. All right, thank you. So other questions then? Did you have a follow-up by Representative Birch?
I did, and I'm wondering your take on the striking from our law this sentence: it shall be unlawful for any person to interfere or attempt to interfere with the rights secured by this chapter, and the effect on, in some respects, making the overall Civil Rights Act something more, something less than it was, more aspirational than violating law.
So I'll let Representative Lynn speak to this since it's his amendment, but I didn't actually understand kind of the purpose of striking out that particular provision. I can understand the language that was added, although I think our position would be that, that's already what the law is. We can't do things that violate the First Amendment as the government. But, the way I read that particular language is it talks about interfering or attempting to interfere with the rights secured by this chapter. There's two ways to possibly read that, because this talks about basically all rights and lawful activities in one way, but it's also, this chapter itself creates kind of a process and a way for people to avail themselves of the protections of the law. I read it a little more narrowly to say, like, if you were to interfere with someone's ability to file a complaint with our office or our ability to kind of pursue these claims, that would be the unlawful act, because it already defines an unlawful interference with other people's rights or activities. So I will say, like, even in looking at that, I've never been 100% clear on what the purpose of that language was.
You hit the nail on the head. Exactly what does it mean?
So why it was removed also remained kind of elusive to me, but that's, because I think, like I said, paragraph 1 references protect people's rights to engage in all lawful activities and kind of things protected by the Constitution. Does paragraph 2 become redundant if it's just meant to reiterate that, as opposed to protecting someone's ability to pursue actions under the chapter?
Right, so the question I had was, by removing that sentence, are you in some way affecting a person's ability to enforce those rights in court, as opposed to a simple statement that people have rights?
Right. I don't think so, because the way it doesn't affect anything about how the enforcement process works. So we still have, and all the enforcement comes through the Attorney General's office. It only vests the Attorney General with the ability to pursue these cases. So I don't think it affects what could happen or what the law protects or allows us to do, if it were to be there or to be removed.
One final.
Yes, go ahead, Representative Birch.
And I know you're somewhat staying away from the word hostility, which is a subjective standard. And I'm curious, because many on this committee are concerned about arbitrary and selective actions by law enforcement, prosecutors, and the like. Forgive me for saying that. And I'm wondering your sense of, because hostility is subjective and undefined, that enforcement decisions may depend on discretionary judgments about what a defendant's internal motivations were, keeping in mind, of course, the Colander versus Lawson case, talking about having too much discretion in the hands of enforcement officials is not a good thing.
So, like I said, as I looked at other states, not all states have that same hostility requirement. There's a lot of different permutations of how hate-motivated behavior gets defined. Some may say kind of, might reference discriminatory victim selection. Some might say kind of motivated by prejudice, motivated by hostility. Some may say kind of, as this original does at the moment, say nothing at all in terms of the kind of the hostility of the motivation, for lack of a better way of describing it. My kind of point is kind of the way this has worked and what it's designed to do is to capture a lot of things that before they become criminal offenses, to kind of protect that public prospectively. That's certainly what A.G. McLaughlin, when he supported the bill in 1999, spoke about in talking about former residents of the Laconia State School who were finding themselves in the community in Laconia and being targets of kind of harassment, abuse, threats. And then that escalated into violence. And so he advocated for this as a way to be able to take proactive steps to protect those individuals. That's kind of what, in terms of whatever language gets chosen, we'd want to make sure we're able to protect those individuals from kind of any form of biased kind of misconduct or biased unlawful behavior, and not create something that's either over-inclusive or under-inclusive.
All right, Representative McFarland.
Thank you, Mr. Chairman. Given that characterizing legislation as taking the state in the wrong direction is a policy judgment rather than a legal or constitutional or technical analysis, and therefore departs from principles of executive neutrality, is the witness representing the position of the governor or an independent assessment of the DOJ?
So I would say we are the ones that enforce this law. So, in the same way that the Department of Health and Human Services may come and oppose a piece of legislation that affects their ability to do their jobs, that's not, that we are the regulator, we are the policy kind of agency vested with this, as opposed to other circumstances where we may come testify to kind of provide, legal advice or guidance to the legislature or to the state, that's a different kind of component of what we do. It's like my colleagues who would come and oppose something or represent something about changes to the laws involving prosecution of homicides. That, is within our purview of what we enforce. To take a position on it in that way is kind of, I think, fairly within our scope of kind of our purview.
Representative follow, yes.
So just for avoidance of doubt, you're saying that this is in fact not the position of the governor, but the position of the DOJ that you're representing?
Yes.
All right. Representative Scully, did you have a question? And then Representative Horn.
Well, I do. In some respects, Representative McFarland has asked my question. If I may make a very brief statement.
Well, why don't,
Oh,
sure,
you
go ahead. As long as it's
No,
brief.
thank you. I guess I would just say I sit on another committee, and we have members of the executive council, the executive departments come before us, and they usually don't take positions on bills, although they're free to tell us what they think the problems with the legislation may be. When I see an executive department come in and start taking positions, especially one as critical as the Department of Justice, it sounds less like you are concerned with the blind administration of fair justice and more as if you've become an advocacy group for a point of view. And I find that a little troubling.
So actually, if I could respond to that, because I think Representative Smith and I have some famous back and forths over the years where we've declined to take positions, and she has expressed frustration at our refusal to take positions on pieces of legislation. But I agree, and I think that decision isn't one made lightly by our department when we take this position to oppose or support a particular piece of legislation.
Representative Horton.
Well, there's there's language on lines 9 through 11. We've discussed a little bit about hostility, and so I'm wondering, are there cases where discriminatory behavior is not necessarily caused by hostility per se, but perhaps by being overprotective of the class or having restricted idea of what their rights should be? And then also, like, on line 10 of the persons that targeted the aforesaid activity, what does that do to cases where there's discriminatory activity, possibly motivated by hostility, possibly not, where there's no specific person being threatened, but they're just sort of threatening violence against a whole class of people in general? So I wonder, should I be concerned that this is weakening some situations where civil rights protection now is in effect because there's not necessarily hostility per se, or there's no particular person being threatened?
Right. So that's kind of where our concerns come from, and that's why those are the two areas where I would be more than happy to try to work to a solution that works for kind of everyone.
All right. Other questions? So I guess, Mr. Locke, I guess one of the things that I have to say, because I have great respect for you and great respect for the Civil Rights Unit, but one of the things that kind of motivated my proposing this amendment is, first of all, I thought Senator Abbas, as I said, I thought he made a really telling point in his testimony before the Senate. But the other thing that concerns me, frankly, is it seems to me that the First Amendment really is under attack in this country. And there's an effort by some to expand, what can be controlled and what you can not be allowed to say, as has happened so to a far greater extent in Europe. But it's very concerning. And when I see things like, and I say this respectfully, but when I see things like that Portsmouth case, which to me that was just so clearly a First Amendment problem. But nonetheless, the Attorney General's office went forward. And then I see things like, the case in federal court of the parents, I think it's from Bow, who went wearing the no violence, no threats, no inciting. They just wore the pink band, and they are enjoined, or whatever happened to them in the federal court. Boy, I say, wow. This and that's what leads me to want to make sure that, yes, we want to prevent harassing. Yes, we want to prevent people from doing things that the statute says they shouldn't do, interfering with violence or threats or whatever. But it can't it cannot however much I might personally hate what, the sign said in Portsmouth, the idea that those people didn't have the right to do it is very troubling to me.
So I have two responses to that. First, to the federal court case, we have nothing to do with that. So I just highlight that that's not our office. We have no involvement with that case. I can appreciate the concern, but that isn't this act. It isn't our office.
Right.
To the concerns about the Portsmouth case, I would say to you, I appreciate that you agree with the outcome of that case. But before we brought that case, it was reviewed by myself, another attorney within our office, my supervisor, the deputy attorney general, and the attorney general. And we all kind of came to the consensus that, this was within our scope of authority to be able to bring this. Obviously, the trial court and the New Hampshire Supreme Court disagreed with us and made their ruling, and that's, their prerogative to say what the Constitution protects and does not protect. But it didn't mean that it wasn't necessarily something that was spoken to in this statute. There was no knowing phrase in this statute when we talked about trespass. That was added through the interpretation of this statute by the courts. So we were acting kind of within what this allowed and what we viewed as kind of within kind of the sphere of what we could bring under the First Amendment. Again,
Sure, but-
others disagree, and that's their prerogative to disagree. But it's not to say that it was kind of, we went off unfounded or without any kind of thought or consideration to limitations. And again, you can shake your head and disagree, but it doesn't mean that that did not occur.
Right, no, I don't for a minute dispute what you have said about the review process, but it does seem to me that even if there were some technical kind of trespass, hanging, the overwhelming majority of the activity there strikes me as core free speech activity. And what really concerns me, and I think other people, is that we can't narrow the First Amendment so that things that you or I might find very offensive, and by God, I completely agree that that was very, very offensive. But it can't be. I don't think it can't be the law that you can be sanctioned for saying things that are very offensive. It's got to be much narrower than that. And this,
And again,
I understand you're not responsible for the federal court case, but my point simply is that that is just another example of the extent to which officialdom seems to think that maybe the First Amendment is not as important as I think it is.
My response to that would be is I would encourage you, and I don't know that there are people here to speak to the folks I've had to tell, we can't assist you because the First Amendment protects the activities of what those individuals did. It includes some of your colleagues, by the way, other state reps and state senators who have been targets of fairly vitriolic, anti-Semitic and racist kind of comments from members of the public. And we've had to sit down with them and say, unfortunately, this isn't something we can do anything about. So I would just caution that, we aren't trying to diminish anyone's First Amendment rights. At the end of the day, we're talking about, it's not the speech that motivates what we take action. There has to be that unlawful act that's defined in the Civil Rights Act, whether it's force, violence, property damage, or trespass.
All right. Other questions? Yes, Representative McFarland.
Yeah, I'd just like to follow up on this conversation because I'm struggling to follow the line of argument that's being presented by the witness, and I would therefore just ask two questions. One is whether, in fact, the DOJ will be proceeding with proceedings against whoever hangs other things on these kind of places, whether it's the U.S. flag or anything else. And in the same vein, how does the witness feel that what we're hearing in testimony here doesn't create a very chilling effect on the First Amendment, on free speech?
So to the first point, obviously, I think the Hood case speaks for itself in the sense of we wouldn't pursue things that are kind of directly in disagreement or contravention of what that decision says. And in fact, there were other similar cases that we were looking at the time that we held off on because of that real legal question. And when it was resolved, we declined to pursue them further. To the point of the chilling effect of speech, I don't know that I have an answer to that question. Obviously, we as an agency, we enforce this law. We've come and kind of explained our position and explained what we look for in these cases. I've routinely told folks, again, people are allowed to protest and disagree with you and express themselves through doing so. So I don't know how kind of us saying people have we repeatedly tell people they have First Amendment right. The people, that they believe have threatened them or offended them have First Amendment rights, and there's little that we can do when their First Amendment rights are involved. I don't know what else to say other than that.
All right, other questions for this witness? Seeing none, thank you very much.
Thank you all.
Thank you. Next, I'm going to, Senator Abbas, I'm going to ask the prime sponsor if you'd come up, please.
Nothing's on time today, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. I'm Senator Darrell Abbas. I represent District 22, the communities of Pelham, Salem, Axon, and Plastow. I'm here to introduce, well, it's already been introduced, but SB 464. I understand that the chairman has prepared an amendment. I have reviewed that, and I think that it's actually an improvement of what my intent was with the original bill. Understand, the law is written right now. It's not written in a way that it has to be targeted at a victim. And the majority of the cases on this subject all point to that. And I understand that the Hood case was brought up. That's the Supreme Court in New Hampshire ruled that it was vague as applied in the circumstance, because let's say you had a permit to whatever message you're putting out there, however hateful it is, once the time period expires by 5 minutes, you're technically trespassing. And if they left it up and I were to walk over and say, oh, that's clearly a hateful message and insulting to people, I'm going to take that sign down, I would be committing a crime simply by taking it down, even if that message wasn't targeted towards me. But I happen to be trespassing and by simply taking it down as it's written. And I understand from the testimony from the prior witness, or when he was answering questions, said they take a position in opposition. This isn't telling anyone how to operate doing their job. This is a policy for the legislator to take into consideration. The prosecutors and the county attorneys then handle the cases when there's a violation of those policies. And obviously they have to meet their burden of proof. But here, that case went all the way to the Supreme Court. It was dismissed on a motion to dismiss, went up, it was appealed by the court, the DOJ, to go all the way up to the Supreme Court, and they upheld it. But without having a victim, when the hostility of the attack on the protective class is targeted at an individual or class of people, it is, to me, setting up selective prosecution, and it's not what we want in the state. And respectfully, the First Amendment protects even undesired speech that many of us, if not all of us, would disagree with the context of what they're doing. But to have people prosecuted for that, I think is not a good policy. And the argument that I was most persuaded by was actually the amicus brief filed by the ACLU. Now, they didn't come in and support the bill. That's a decision of that organization. But in their brief that they filed, and I'll just, if Mr. Chairman, I can read from the brief on page 8. It says, the vast majority of enforcement actions for bias-motivated offenses address circumstances where the defendant targeted another person or group for unlawful conduct because of the other person or group's protected characteristics or association. It's focusing on there being an actual victim of this hateful messaging or of any type of violation or discrimination towards their protected class when committing any of these offenses. Your trespass may not be related to what this, quote, civil rights violation is, but by the mere fact that the two occurred in a close in time period, the victim might not even be, the victim of the civil rights violation may not be the victim of the trespass. And that's another thing that wasn't even discussed in the Supreme Court case. So it's supposed to be related, but in that case it wasn't. But that wasn't even an issue raised. That was one of the arguments I thought was overlooked. So I think what this does, and from what I understand from what was presented before the Senate Judiciary Committee, this is how it's generally going to enforce in the state. Now, obviously, in the Hood case, that's not what happened, but when it's a victim is targeted is really when it's how this is supposed to be done. So I think this would put it in line with what I think is the practice anyway.
All right.
I'll be happy to answer any questions.
Thank you. Question, Representative Birch.
Thank you, Mr. Chair. Thank you, Senator. I want to ask you a bit about the phrase substantially motivated by hostility, which combines two indeterminate concepts. A degree-based modifier, substantially, and a subjective emotional state, hostility. Neither term is defined in the legislation. Both are open inherently to interpretation. So I'm wondering how that correlates with the concern that the U.S. Supreme Court has expressed with statutes relying on subjective terms that lack objective benchmarks. I'm referring, and perhaps you can discuss, the case of Coates versus City of Cincinnati, where the Supreme Court invalidated an ordinance that used the term annoying conduct. So if annoying conduct is so subjective that the Supreme Court says no way, how is substantially motivated by hostility constitutionally better?
So I haven't read that case in its entirety, but I get a good feeling you have and could explain it better than me. But so I'm not going to address that specifically, but I'll just use myself as an example. If, let's say there's a description out for someone who stole property, 6 feet tall, 215 pounds, early 40s, Middle Eastern descent, and someone then sees me, grabs me, whatever they do. Although their action towards me, and I'm not to say I'm the wrong subject, their action towards me is motivated by what my race is, right? But there's no hostility there, right? That's what the hostility is not because of that, but you can make an argument that it is simply for the way I was targeted. All right, that to me, substantially motivated is that's what's driving you to do what you're doing. The threat that you're making towards the person is motivated by their race. That would have to be what this would
I could
entail.
follow
Now,
up.
the hostility side, by the way, if I may, is you can't simply saying a racial slur, highly offensive, inappropriate. Saying something, a derogatory term about someone's sex or gender or someone's religion, inappropriate. But if it's not, that in and of itself can be interpreted as an act of hostility, but it has to be targeted at a victim, not just a generalized statement.
But if I could follow up.
Yes, follow up.
The proof of the pudding is in the eating. So my question to you is, how does law enforcement or a prosecutor deal with what is a script that a bad actor can follow who is doing a graffiti on a synagogue or harassing a gay person while saying, I love you, man. I love you, man. I have no hostility in my heart. I did this painting on the wall of the synagogue because I think it's beautiful. I got nothing against Jews. And I have a big sign here saying I'm not acting substantially motivated by hostility. I have no hostility at all. How is that dealt with?
Well, first of all, most people who are arrested for crimes deny or that they actually did it. Two, in respect to law enforcement, they're making the arrest for the underlying threat anyway. There's an underlying crime that's going along with this. It's not as opposed to the single issue here. So is my understanding of how this could operate. In regards to someone spray painting or any type of religious institution, when they're not that religion, let's say, oh, I love these folks and I love this religion. That's for the fact finder to decide. But most people trying to communicate hateful speech or commit these type of acts, they're doing it for a reason. It's because they have hate in their heart towards a class of people, and they want their message to be received by the victim. That's what is the motivating factor.
But isn't it a basic constitutional principle that that laws have to be understood by the citizen before the citizen, with reasonable certainty, before the citizen can be charged criminally or civilly with violating it? Doesn't there have to be a certain level of specificity rather than saying a judge or a jury can figure it out?
Well, substantially motivated by, that language, the word substantially is just used in a lot of different areas, whether it's, civil or it appears in a lot of different RSAs. I think the court often also applies the plain meaning of a word when if it's not defined specifically in the law.
All right, other questions? Yes, Representative Mann.
Thank you. Thank you for taking my question. Would you believe that in the harassment statute, it says makes a telephone call with no, at inconvenient hours, but it also says, or in offensively coarse language with the purpose to annoy or alarm. Pretty much similar to what the language in this amendment is. How do we define that? So it's already, that kind of stuff is already in statute. Is that true?
There's a lot of laws in the books, and I agree.
Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Vanessa Blaze, please.
Good afternoon, Mr. Chair and members of the committee. Thank you for hearing me speak today. My name is Vanessa Blaze, and I serve as the Director of Policy and Planning for the New Hampshire Council on Developmental Disabilities. I'm here today providing testimony on behalf of the DD Council membership, which believes that this bill would negatively impact the New Hampshire developmental disability community. As you heard earlier, the New Hampshire Department of Justice made clear that this bill would move the state in the wrong direction, reducing rather than strengthening the protections of our civil rights laws. And the department has called on lawmakers to instead work to modernize these laws. FBI data shows that hate crimes against Americans with disabilities rose almost 30% over 5 years from 2019 to 2023. And that trend alone should be very concerning to this committee. But a more alarming figure lies beneath it. A 2019 comparison of FBI police report data and Bureau of Justice Statistics crime victim survey data found that law enforcement recorded fewer than 0.5% of anti-disability hate crimes that actually occurred. And this is not a reporting gap. This is a near total absence of legal accountability. This exhibits that for people with disabilities, the law's promise of equal protection is in practice barely functioning. When a minuscule fraction of incidents is ever formally recorded, the legal system is not serving the disability community. This pertains directly to the question of legal standards, adding the requirement that bias be substantial motivating factor in the conduct of the perpetrator. Courts have interpreted this to mean that more than incidental prejudice, meaning bias must genuinely drive the act. This increases the evidentiary burden for victims to meet. When the cases that reach the legal system already represent a fraction of actual incidents, that burden falls on the most vulnerable victims. Weakening the statutory framework around that standard does not simplify the law. It renders an already strained protection functionally unreachable. The DD Council membership is concerned with the prospect of adopting legislation that narrows civil rights protections for a population whose victimization is chronically undercounted and underreported. If the standard of substantial hostility is already difficult to meet in practice, the answer would be to build better pathways to justice, not to fortify the barriers to it.
Questions for this witness? Representative Horgan, did you have a question? No. Oh, I'm sorry. All right. All right, thank you very much.
Thank you.
Next, I'm going to call on Grizzly Glenn, please. Grizzly, I'm sorry.
Grisali.
Grizzly, sorry.
Hello. My name is Grisali. I'm from Manchester, New Hampshire, and I'm here in strong opposition to SB 464. Although I'm just one person, who I am, where I'm from, and what I've experienced is representative of many others just like me. This bill requires that harm be substantially motivated by hostility. I want us all to be clear about what that actually means in practice. Discrimination rarely presents as obvious hostility. It is seldom explicit, rarely admitted, and almost never provable through a single incident. It appears through patterns, repeated behavior, and decisions that consistently disadvantage certain individuals while remaining subtle enough to avoid clear evidence. Discrimination is the action, but it is often driven by bias, and that is not openly hostile. A standard that focuses on hostility ignores how discrimination actually occurs. Another concern is the range and the complexity of discrimination itself. People experience discrimination based on race, gender, disability, religion, age, identity, and often a combination of these factors at once. It can also be tied to socioeconomic status, how someone is perceived based on income, housing, or class. These experiences are layered, intersectional, and develop over time. So when something that is already complex and difficult to prove is narrowed to require proof of substantial hostility, the result is a standard that fewer and fewer experiences will ever meet. That does not reduce discrimination. It reduces accountability. It's also important to recognize that this language is not accidental. As an attorney, the sponsor understands exactly how standards of proof function in practice. Requiring that harm be substantially motivated by hostility does not simply clarify the law. It raises the threshold in a way that makes many legitimate claims significantly harder to prove. This reads less like a response to real-world discrimination and more like a legal standard designed to limit liability for those accused of it. Because this language does not reflect how discrimination actually occurs. It reflects how difficult you want it to be to prove, how difficult you want it to be to prove. And that is not neutral change. It is a shift in who the law ultimately protects. And that is especially concerning given the current reality. Accountability is already inconsistent. Complaints are often dismissed or go unaddressed. People already struggle to have discrimination recognized, particularly when it is subtle or systemic. So the question is, what problem is this bill solving? Because it's not addressing a system that is too easy to hold accountable. It is making an already difficult system even harder to navigate. And that leads to a more important question. Who does this actually benefit? Because it does not benefit the people experiencing discrimination. It benefits those whose behavior is subtle enough to avoid clear proof while still causing harm. I also want to speak to what feels like a clear disconnect. When I look at this bill and compare it to the people in my community, my people are actually experiencing, those two things don't align. The people I know are not asking for higher barriers to proving discrimination. They are asking for accountability from systems that already hold significant power in their lives, whether in housing, employment, education, or institutional decision-making. Those systems already operate with a level of authority that can be difficult to challenge. So when legislation makes it even harder to hold that power accountable, it raises concerns because it does not feel like a response to the needs of the people. It feels like a shift that further insulates power from scrutiny. So again, whose constituents asked for this? I am also genuinely interested in how this bill came about because when I look at the impact it would have, I do not see the needs of everyday constituents reflected in it. So I have to ask, who is asking for this bill? What individuals, organizations, or interests identified this as a problem that needed solving? What evidence exists that the current standard is too low? Because from where I've walked, from where I've seen, and from the people I've stood alongside, the problem is not that discrimination is too easy to prove. The problem is that it's already too easy to ignore. The people I live among are not asking for weaker civil rights protections. They're asking to be heard. They're asking for accountability, and they're asking for the system that actually works. We do not need higher standard for proving discrimination. We need a system that actually enforces the standard we already have. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Karen Rosenberg, please. Or, I'm sorry, do you have a written copy of your testimony? Oh, okay. All right, that's fine. If you just hand it to Representative Ball right on the end here, please. If you just give it to Representative Ball right there. Thank you. Yes, Ms. Rosenberg.
Good afternoon, everybody. I know it's late. My name is Karen Rosenberg. I'm the policy director for the Disability Rights Center, the state's protection and advocacy system for people with disabilities. The Disability Rights Center is in strong opposition to this bill because we feel that it would diminish protections for people with disabilities and others, but our focus, of course, is disability. Establishing some very vague, undefined terms to prove violations of individual civil rights is simply not going to protect people who are very vulnerable in our communities for such violations that impede their ability to live in our communities safely and without being harassed or coerced. It's not difficult to think about the resentment that we hear about from communities when a community residence, for example, moves into their neighborhoods, and we can envision a situation in which neighbors are unhappy and may do terrible things to make the person or the couple people living in a community residence feel unwelcome. That could include blocking their driveway, driving up on their driveway, hurling terrible language at them that's really offensive, making them feel unsafe in their own homes. Under current law, those folks, if they filed a complaint with the Attorney General's office, it is possible that the Attorney General would take that on for them and be able to secure an injunction to prevent that kind of harassment so that they could live their lives. If this happens, if this bill passes, I can envision a situation in which a neighbor would say, oh, we just don't like all the cars that are being parked in our neighborhood. So does that mean that there's no longer that their conduct is no longer substantially motivated by actual or threatened like hostility? Or we don't like that there are people coming in and out at all hours. Well, maybe the people who are coming out at all hours are the 24-hour staff that are enabling people with disabilities to live in their communities. So is that going to prevent, does that mean it's not like substantially motivated by the person's protected status as someone with a disability? Making it harder to prove these cases is not going to help anyone here. It's not going to help people who have been historically victimized because of their belonging to a protected class, such as based on disability, race, religion, all the other ones. It's not, this isn't going to help them. I think what you've heard, though, is that if there are concerns about the potential infringement on First Amendment rights, that there's a willingness from our Attorney General's Office, Civil Rights Office, to work with you all on language that could clear that up. But making it more difficult to prove these cases where we already have a requirement that, that the declaration of the intent to inflict harm on a person or a person's property is done with a purpose to terrorize or coerce. That's already a pretty high standard. It shouldn't be weakened. So thank you so much for your consideration. And again, we strongly encourage you to ITL this bill.
All right, questions for this witness? Seeing none, thank you very much.
Thank
Next,
you.
James McKim, please.
Thank you, Mr. Chair and committee members. My name is James McKim. I'm a Goffstown resident, a parent, business owner, obviously a person of color who's been involved in civil rights cases. Some of you may know me as past president of the Manchester NAACP. However, today I'm here in my personal capacity. I'm here today because I know what racism feels like and how difficult it is to prove. even when it's happening right in front of you. I appreciate the desire of the sponsors to clarify RSA 354B1, indicating targeting of a victim. Having said that, discrimination, as has already been described here, is not usually obvious. And when you speak up, you're asked to prove more than any person should ever have to prove. As theologian Reinhold Niebuhr said, all human sin seems so much worse in its consequences than in its intentions. That's exactly how discrimination works. Rarely announced, but deeply harmful. And if our laws only look at intent, as SB 464 would, they ignore the real damage people live with every day. That is why this bill scares me. It introduces phrases such as substantially motivated and imminently inflict harm, but does not define them. And I understand that some of these terms are used in other legislation where they defined. Could someone, I have personal experience where people have winced or moved to the other side of the street when I've been walking down the street. Is my walking down the street then to be interpreted as my going to imminently inflict harm? Could someone harming me because they felt I was going to imminently inflict harm to them just by walking down the street be protected by this law? For people who face discrimination based on race, religion, sex, the protected classes, vague language doesn't make the law more fair. It makes justice harder to reach. It shifts the weight even more onto the people who've already been harmed, demanding that they prove not just that discrimination happened, but how much hostility was behind it. That is not justice. That's a higher hurdle for those who are already carrying too much. Civil rights laws were written to protect people from unequal treatment, even when intent cannot be proven. Raising that standard means fewer cases, fewer violations addressed, and more people left in silence. It tells protected groups their safety and dignity are negotiable. And make no mistake, people notice in workplaces, in schools, in housing, in daily life. They notice when protections are weakened. SB 464 would increase fear, not confidence, among people who already face exclusion. Our Constitution promises equality. My overall question about SB 464 is, how does this strengthen rather than weaken that promise? Rights can't be protected in practice, or rights on paper only. I urge you to vote ITL on SB 464. Thank you, and I'm happy to take any questions.
Thank you. Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on Grace Kindecki, please. Kindecki.
Hello, Mr. Chairman. Thank you for taking my testimony, and many thanks to the committee for taking my testimony today. I know I'm sure it's been a long morning and it's quite hot in here, so I'm sure you all are feeling a bit ready to get up out of these seats. My name is Grace Kindecki. I am a longtime New Hampshire resident. I grew up here in New Hampshire. I am a Manchester resident. I'm a homeowner. I'm a taxpayer, and I know all too well the ways that discrimination can manifest itself in our state, as great as it is in many other ways. I'm here to urge the committee to vote ITL on SB 464 because, as my other colleagues and community members who've been up here have said much more eloquently than I, this does not increase protections. This does not make us stronger. It, in fact, it weakens our laws, our protective laws, in ways that is utterly unnecessary and, in fact, works against what I know so much of the work that you all do on this committee and beyond to ensure that New Hampshire is a strong and safe community and state for all who live here. So I'd like to share 2 quick stories with you. And I will caveat and say I'm not a lawyer. None of these stories ended up with me filing a civil rights case because I didn't even know I could at the time. But when I was a child, walking the street, going from the ice cream shop to my house, 2 gentlemen in a truck, 2 white gentlemen, yelled the N-word at me and threw a Dunkin' Donuts cup in my general direction. They sped off laughing, cackling like hags. And under the premise of this law or this bill as it's written, their motivation could be claimed that they were just trying to be funny, that they thought it was a joke, that they were just being, as we like to say, boys being boys, just being silly. But the reality is that the N-word is not a meaningless word. It is a word that symbolizes hate in many forms. It is a word that was used when people were being killed. It was oftentimes the last thing that people would hear before they were annihilated off of this planet. Symbols have meaning. And in fact, the symbols behind the chairman's chair, and in fact, even the chairs that you sit in, are examples of that. Symbols mean something. Words mean something. And one of the things that we teach our children, and I hope these lessons continue on into adulthood, is the reality that despite what our intent may be, and it's important to understand what the intent is, but it does not outweigh the impact of our actions and behaviors on others. And so we must understand the impact that hateful words, hateful symbols have, not only on individual people who are being targeted, but also on entire communities, whether those people come from those communities directly or they're in relationship with those communities. I know I'm probably running out of time, but I'll just also include an additional story, one that's a little bit more recent, because I know I look forever young, but I'm in fact almost 40. So this happened a little bit sooner. I was taking a walk with my mother, a nice summer day last year, on the Merrimack Rail Trail. And it was lovely, the flowers were out, the birds were singing. And we walked past a bridge, and there was a gigantic swastika that was placed on that bridge. And it stopped us in our tracks, not because we are Jewish, but because we understand and know what that symbol stands for. It stands for hate. It stands for, and possibly the people who had committed that would likely say, no, we're just expressing ourselves. We're just showing it off. But I do want to make sure that we understand, we used it as an opportunity, my mother and I, to have a discussion about what one does to survive authoritarian regimes, what one does to survive genocide, both, at the local level, but also at the government level, because my mother grew up under a dictatorship, and and the reason I am here is because she escaped that dictatorship. So I do think it's important for me to share this story with y'all, not only because, Manchester is my home state. I would like to share these personal stories with the committee, and I know I'm likely running out of time, but I just wanted to emphasize the importance of understanding the intent and how we weigh that against impact and the power that symbols have, not only on people, on individual people, but on all people in all communities, and what that does to the social fabric and the social contracts that we have. I understand that this is an argument about the First Amendment, and there absolutely, of course, we all have the right to freely express our opinions, no matter how hateful it is. But there is a difference when those opinions are being targeted at people and the impact that has on people. I'm no lawyer, but I've heard folks talk about the bridge, the white, New Hampshire's for white people only banner that was placed on the bridge, and some of the technicalities of that. But there's a difference between, okay, I'm going to show up in a public space, in the public square, with a sign on my chest, and be waving my, New Hampshire is for white people only banner in my hands. And there's a difference between doing that and leaving that message on a bridge where people are passing by and are seeing it. And then whether you're white or not, having loved, if you are a person of color or not, seeing that message and seeing and hearing that New Hampshire doesn't, you're not welcome here. You're not allowed to exist here. And as someone else said much more better than I, it is important to understand, who does this bill protect? What is the point or the purpose of weakening our civil rights laws when it is already so hard to enforce them? What is the purpose of weighing the desire and the need, which is already protected, to say whatever you want? You can say whatever you want, but there are consequences to the things that we say because of the impact that it has on the people who are, whether or not intentionally, but because symbols have power, are hearing that message loud and clear. And so I want to just close by also bringing up the example of the pink armbands. I think, Chairman, you shared this. It's one thing to have a private party or to go hang out with yourselves in a park and wear a pink armband that means what it means. We don't want trans girls to be playing sports. Fine. Go ahead. Of course, you can absolutely play that. You can actually wear that. But to wear that symbol that you have imbued, to wear that item with the symbolism that you have imbued in it at a game where there is a trans child playing, the impact that that has on the individual, the impact that it has on the family and the community of people who love that child, who are in relationship with that child, outweighs whether or not you just have the right, you should go scot-free because you have the right to wear it. You absolutely have the right to wear it. You have the right to do whatever you like. We live in a free nation. But we cannot, and my hope is that the committee is able to weigh and understand, and at the very least be willing to study this law more deeply to understand the impact that it would have on the people of the state, especially because all of you sitting here are representative of the people of the state, even if you do not directly belong to the communities which I may belong to, that my colleagues behind me may belong to, but you're imbued with the power, the authority, and the duty to weigh the impact these laws have on people who too often, whether it's because of their disability, whether it's because of their race, whether it's because of their gender, are already under so much attack. And to ensure that whatever comes through this committee comes out because it goes forward in strengthening not only the ability for all of us to be able to exist, live, pray, work, worship in the state, so that we can continue to contribute to it as we have done and continue to do, without always having to negotiate whether or not we're able to exist. Thank you.
Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Michael Haley, please.
Thank you, Mr. Chair. I'll be very brief. Michael Haley, I'm from Derry, New Hampshire, and I work with GLBTQ legal advocates and defenders. I did not prepare written testimony because I was really here for the bill before this, but just listening, in some of our work, there are some things I encountered that I thought would be worth bringing to the committee's attention. I'm not a First Amendment expert, unfortunately, but so we are often contacted by organizations who want us to come and speak to them about how they can best support the LGBTQ community. And the last year, we've had a large number of faith organizations contact us to ask us to come. And in New Hampshire, I've gone to a number of churches, and they have told me, it's really important to our faith that we are accepting to everybody, regardless of race, regardless of gender, regardless of LGBTQ status. And we're concerned, though, because we are aware in New Hampshire of a number of cases of churches putting up pride flags, affirming messages, and having those vandalized and torn down. And up until and under the current statute, I believe that we could say, well, if that's what happens, someone like vandalizes your church because they are opposed to LGBTQ people, the statute covers them. But if you're saying that it has to be motivated by animus towards the victim's sexual orientation, then that removes the protection from those churches. We already heard from the DOJ that there's not a particular protection for houses of worship in New Hampshire. The church itself is not gay or transgender, so this would remove that protection from these faith communities who do believe that this is an important part of their faith and practice to show welcoming and affirmation to all comers. And the other thing that we've encountered, is like pride celebrations, right? So there are a number of cities across New Hampshire that will host pride celebrations. A lot of people who attend those pride celebrations are themselves LGBTQ. Many of them are not. And so if someone attends a pride celebration, again, as we heard from the DOJ, that we have heard of threats being made against these assemblies, if someone attends with the intent to terrorize and to scare people and to say LGBTQ people are not worth it, are not welcome here, and they assault somebody, the outcome of their situation is different depending on if they happened to hurt a gay person or if they happen to hurt a straight person who is attending. Their intent, their animus is towards the community. But if they go into a pride celebration and punch somebody because they're there and they happen to be straight, they've accomplished their goal of terrorizing people. But the person who is the target of that attack or the victim of the crime is not themselves in a protected class. So this statute no longer applies. And under the current law, I think it would serve to deter the type of conduct that we're trying to deter, which is telling people that because of these protected characteristics, that they are less than, that they are unwelcome in the state. I think those are both examples that don't really touch on First Amendment. We're not like talking about assault and vandalism. Those are not speech necessarily, and they're certainly, as far as threats go, outside of the scope of the First Amendment. But I felt that I would want to bring to the committee the committee's attention to those things that we've encountered and concerns that community members have raised with us.
Thank you. Questions for this witness, Representative Horton?
A corollary to that, what concerns me about the amendment, and which you may have thought of the issue not, what if somebody is of one protected class but is mistaken for a member of another protected class? I know there are a number of cases over the years where, like, for example, members of other religious, for example, like the Sikh community, they're a minority of religion here in the United States, and they're often attacked by people who actually have animus against Muslims and may not even know what a Sikh is. Or if I can apply it to myself, what if somebody really didn't like Russians, and because I have blonde hair and blue eyes, like many Russian people, they attack me.
I'm sure there's a question here.
Yeah. So, does this bill also make it hard to prosecute? Also, probably cases where somebody actually is a member of a so-called protected class, but the assailant had a different protected class in mind when he went ahead and attacked the person.
Thank you for the question. Yes, I think this does heighten the burden of proof that the DOJ has to show in these situations. And not only that, but it requires that the perpetrator be correct about their assumption, even if their ultimate impact is the intended impact, which is to terrorize and to threaten people.
All right. Other questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Caden Dole, please. Pardon?
I wrote it neater this
time. Oh, yes, you did. You did. Thank you very much.
Yes. Well, hello again, everybody. I'm Caden. I'm from Newmarket. I'm a private citizen here in New Hampshire. And for 5 years, I was a resident dean at a college. And I dealt with graffiti swastikas and the N-word being written on desks and bathroom walls. And I also responded to direct threats that were aimed at entire communities. And what I learned in that time is that, one, you can't always identify a singular victim. And two, the needs of the community impacted are often to feel safe again, which includes sitting and having real conversations about, and a lot of learning about what went into those actions and what we need to do as a community to ensure it doesn't happen again. This bill doesn't remove the freedom of speech to say whatever you want, but it removes the ability for a community to heal and for the greater community to learn from that. So completely besides the issue related to free speech, there are systems at the systems level, which you all see every single day as legislators, that, I lost my spot, sorry. But there are systems that impact entire communities, right? And there are systems that we don't necessarily recognize are impacting certain communities unless we're members of that community. And I'm gonna, for just a second, I'm gonna say something that might be a little bit off-putting. But before I say it, I want you to know that I too have felt that discomfort, and I'm probably not gonna say it perfectly, so I hope you can give me grace and just sit with it for a second, because I think it's really important. What I'm gonna say is that as I look around this room and at all of you, I notice how many white legislators are voting on this bill and are hearing testimony about this bill. And I don't say that to say that being white is bad or automatically makes you racist. It doesn't. But it gives you one perspective of this and not another. It doesn't give you the lived experience of another. I'm also going to ask how many of y'all are men versus how many of y'all are women. And again, I don't say this to imply being a man is wrong or bad. I'm a man too. But who's here? Who's in the room, right? And I assume all of you here have had conversations with each other, real conversations with each other that have led, that are respectful and important and bring new perspectives that strengthen your legislative process. I would hope, right? And I say those things simply to pose the question to ask, should we consider stepping into someone else's shoes and listening to our Black and brown neighbors when we're talking about this bill? Should we listen to women who've historically been barred from the roles like the ones you hold today when we talk about this bill? Should we listen to the disabled folks who lay on the steps of the Supreme Court to ensure equal rights and the hard work of the individuals here in New Hampshire when we talk about this bill? Those are real systems level civil rights issues that don't have a singular victim. And they weren't necessarily a clear outward violent action, right? But I hope we can all agree that desegregating schools was important and a huge piece of our history that we can, be proud of and thank many people, such as Thurgood Marshall, for helping us get there, right? And as individuals, I think we can all consider positions where there's been clear bias about something relating to us, regardless of what it was, and how we felt, and what we wish we could do to make sure our perspective was heard too. And as individuals, we have power, but we can't necessarily do those things alone. And that is why the original law was written as it was. Sometimes we need to identify the unfair treatment as a community within a system. And this bill would remove that legal pathway, that peaceful legal pathway for fair access. And I think we should also consider the very hard work of many people who came before us to instate laws like this, including people that we considered heroes in history class in elementary school, right? Again, people like Thurgood Marshall, people like Roy Wilkins, who wouldn't have been able to focus on legal challenges surrounding segregation, Frankie Lou Hamer, working on equal voting rights for Black women and for all women, for women to serve as legislators. Those groups are not individuals, right? And like I said, there are groups who still experience challenges today that we don't necessarily see unless we're there, right? I'm sure we can also agree. I mean, I grew up in a fairly rural area of the state. I've heard many times people say, oh, you must be, people who live in rural areas are stupid. And that's just not true. And I personally really hate that perspective. And I want to be able to have those conversations with people, and I want to be able to impact the police. But you have to do that as a community. You can't do that alone. So my question to all of you, because I'm going to wrap this up. I know that we've been here for a while, but thank you. This is a very important issue. But my question to you is, what kind of community do we want? And what kind of pathways do we want for our kids to have to fight for their own rights if they need to in the future? And what pathways do we want to ensure that, I don't know, for example, we become temporarily injured, that our employer can't fire us while we recover. This is something, civil rights violations don't just happen to individuals, and it impacts everybody. As a white man, right, I am impacted when women cannot participate in certain spaces. So I ask you to just keep in mind the larger systems and ITL this bill that's going to remove the important pathways for people and communities to move us forward as a society. Thank you very much for your time.
Questions for this? Yes, Representative Mann.
Thank you, Mr. Chairman. Thank you for taking my question. You mentioned the race of everybody on the board here, all the committee members. Can you tell any committee members' creed, national origin, religion, physical disability, sexual orientation, or gender, and whether or not they have walked in the shoes of somebody who's been discriminated against?
No, and that's part of my point is that we all have different perspectives that we bring to the table, and we need to listen to each other for that reason. And we need to listen to the people who have and who are speaking up here today saying, hey, this is really scary because my rights have been infringed upon in the past. And so I'm asking you to please allow for this legal pathway to continue existing.
Thank you.
Other questions for this witness? Seeing none, thank you very much. I don't have any other pink cards. Is there anyone else who wishes to be heard on SB 464? Yes, sir. Did you put in a card? Well, you may have for the previous bill, but you didn't for this. Oh, okay. Come on up. Come on up. No problem. Just tell us again, please, your name.
Of course. My name is Scott Files. I'm coming from Somersworth.
Okay.
And I'm coming here today just as an everyday citizen. I am by no means an expert on civil rights, not a lawyer, but I've really appreciated the testimonies before me. When I was reading through these proposed changes, the things that stuck out to me that I won't take up too much time, substantially seems incredibly subjective to be added to a protection. Adding substantially seems to say to me it's okay to commit a violent act or make a threat that's only a little bit motivated by race or homophobia. And I fear, as one gentleman spoke earlier, like they've had to say, sorry, the burden of proof isn't high enough for us to make a case for you. Adding substantially is going to make that burden of proof even higher, and would probably prevent people from coming forward if needed to defend their civil rights if they've experienced a threat or a physical attack. And also, what will substantially mean in practice? Will we only find that out when cases are tried and we find out then that isn't substantial enough or that is substantial enough? And last that I want to mention, someone's motivation doesn't need to be hostile to be harmful. That has been mentioned by some others today, and I think that's a really clear, like a really important distinction to make. And also, there doesn't need to be a single direct victim for a hateful act to affect an entire community. Putting a swastika somewhere that might not affect a specific business or a specific place of worship doesn't mean that that doesn't affect the entire community that might be harmed by that symbol. And that is all I've got to say today on that.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Now, is there anyone else who wishes to be heard on SB 464? Seeing none, I'm going to close the hearing on SB 464, and I'm going to open the executive session on SB 464, and I will recognize myself. First, I move. First, I would move on to pass, but I'm going to first refer to my amendment 2026-1369H, and I would move that amendment. Is there a second?
I second.
All right, so it's been moved by me and seconded by Representative Kutab. And if I could speak briefly to the amendment, I paid, as I tried to indicate, I paid very close attention to the testimony that was offered in the Senate. And as I think uh, Attorney Locke indicated, or did not dispute, maybe would be a better way to put it. The way the law is now written, it is obviously overbroad because I think Representative Senator Abbas's example was right on point. If you take the Portsmouth case as an example and forget about the whether it had to be intentional let's assume it was actually a trespass. The way the law is now written, the same liability and being subject to an injunction would apply to the person who trespassed to hang up the hateful sign or the person who trespassed to take down the hateful sign. That is overly broad. And what we're relying on under the current law is the good faith. And I completely agree that the Attorney General's office acts in good faith. The good faith of the Attorney General in exercising, for lack of a better term, prosecutorial discretion, not to bring the case against the person who took down the hateful sign. But that shouldn't be the law. So that necessitates why there needs to be an amendment. So let me address the specifics. First of all, I tried to draft this amendment so that there would not have to be so that you would capture, and I believe the amendment does capture the situation posited by Attorney Locke of the people who attempt to, they paint a swastika, for example, on the house across the street from the synagogue. I think that the language in this bill captures that because the question will be, who was the target of the aforesaid activities? And in a trial, sure, there might be there always may be a case in a trial of a contest over what the facts were or what the motivation was. But if the state could prove in that trial that the motivation was to target the synagogue, then it seems to me it's covered by the statute, which is what was intended. With regard to the issue of both substantial and hostility, respectfully to my colleagues on the other side of the aisle, those terms have been used in the law in various contexts for a long time. I believe that's in the criminal statute in terms of sentencing enhancement. I haven't heard any argument or am I aware of any that's been a problem in applying it in the criminal context to hate crimes. It's just those are words that courts will have no difficulty enforcing. Now, is it? I would have to concede. Is it adding the word substantially? Does that impose a higher burden to some extent on the state? Yes, I would concede that that's the case. The problem is that we have a circumstance where this case frequently, these cases brought under the statute, frequently impact First Amendment rights. And so by upping the burden just a little bit, not tremendously, but a little bit, by adding that word substantially, it seems to me it alleviates, at least to some extent, the clash between First Amendment rights and the protections that the statute is designed to offer. And I think that's very important because, as I said before, it seems to me that the First Amendment really is under attack, and that's something that we have to be seriously concerned about. And let me give you an example, and I say this with the greatest respect to this witness who appeared here, who provided, I think, very eloquent testimony. But the woman who appeared before us and gave the examples of the two circumstances of someone throwing a coffee cup, a Dunkin' Donuts cup at her and using the N word, and then seeing the sign with anti-Semitic, the anti-Semitic sign posted. If I understood her testimony correctly, and I think I did, is she would say, yes, I have no problem with someone, a hateful person being able to use the N word or I have no problem with some hateful person being able to post, being able to have anti-Semitic views, but you just can't say it in public. You just can't put the sign up there, or you just can't use the N-word to me. As much as I am sympathetic to that being a really hateful thing, I think the answer under the First Amendment is yes, you can do that. Using the N-word, however terrible it may be, is not violence. It's not a violation of your rights. It may be hateful. I'm certainly not associating with somebody who does that, who uses that kind of language, but it's protected by the First Amendment, and that to me is critically important. That brings me to the last 2 points I'll make. I included the word imminently because I think, again, this is important. If, I said in our caucus this morning, if I say, to quote from Shakespeare, let's kill all the lawyers. First of all, I think most of the people in this room would raise their hand and say, where do I sign up? But let's kill all the lawyers. That's protected by the First Amendment, as opposed to my saying, there's a bunch of lawyers over there, let's go kill them now. That is not protected. But and so my concern is that imminently, including the word imminently, again, narrows the reach of the statute. Now, is it technically constitutionally required to do that? No. I think that Representative Birch pointed out that there's some case law that suggests that no, that may not be required. But when you're talking about situations where the First Amendment may be impacted, again, go back to my example. It seems to me that it shouldn't even be a close question about whether if I say let's kill all the lawyers, that I have the right to say that, and that there's not any question that somebody's going to try to get an injunction against me because lawyers feel threatened. We have to give some signal in advance that don't be careful because he's going to say something that you might disagree with or you might feel threatened by. There should be no question about that, and that's why putting the word imminently in is important, because it says before you can get relief under this statute, it has to be that I'm saying in a sort of serious way, let's kill all the lawyers right now. Let's take this action right now. And if it's not that, then it's protected by the First Amendment. And the last point I would make is with regard to paragraph Roman numeral 2. As I think, again, Representative Locke, Assistant Attorney General Locke, for whom I have great respect, I think he acknowledged in his testimony the language of that law, of the bill, of the language in Section 2 as it is now. What does it mean? I mean, I think he said it's not really clear what it means. And that's exactly the point. It isn't clear what it shall be unlawful. Well, what does that mean? It's unlawful. Does it mean you're subject to a civil suit? Does it mean you've committed a crime? We don't know. And to interfere with, does that mean interfere? I mean, talk about a broad term. Does that mean that if one group of people is out protesting, for example, that this employer is being unfair to labor, let's say it's a labor dispute of some kind or other, that another group who might have a different view, that they are sort of shouting, both sides are shouting, and the pro-management group is shouting louder, that they have interfered with the exercise of rights by the pro-labor group. It just seems to me that it can't be that could be the basis of taking some action against the one side or the other. It just is too broad. And so I think that's the reason to take it out. And I think it is important, because of the First Amendment implications, to put in its place this language that the statute is not intended to interfere with constitutional rights. I think it needs to be said. So I'm sorry I've gone on so long, but those are the reasons why I think the amendment is important. Representative Birch.
Thank you, Mr. Chair. I'm going to. Thank you, Mr. Chair. I'm going to speak not as great length. And I'm not going to wrap myself in the First Amendment. And my comment, because I think this is essentially a question of whether we're going to reduce the efficacy of our civil rights laws in New Hampshire. I also, not sure I need to point out that on one hand, we have a hypothetical about what would happen if somebody tore down a inappropriate sign they felt was inappropriate and could be prosecuted. Not that I've heard that anybody was or would be. And I want to balance that against the lives and experiences of the witnesses who came in today and talked about how important it was to them that we have an effective civil rights law in our state that can be enforced. And I would note, other than the sponsor, there wasn't a single witness today that spoke in favor of the amendment or the proposed legislation. So I think balancing the lives and experiences of real people against a hypothetical should come out in a certain way. So let's not sugarcoat what this amendment does. It doesn't openly legalize discrimination, but it certainly hands those who discriminate a roadmap on how to defend it, and then weakens the very law that's supposed to stop them. This amendment shifts the focus away from the harm and onto the defendant's claimed state of mind, requiring proof of hostility. This is not a refinement. It's an invitation to avoid accountability, giving bad actors a script. I wasn't hostile. I had neutral reasons. And it gets worse. And I may have to disagree with somebody who spends far more time on this than I. By striking the words, "it shall not be unlawful," the amendment strips the statute of its teeth, replacing a clear legal command with something far more ambiguous and far less enforceable. Striking the phrase, "it shall not be unlawful," is not cosmetic. It fundamentally alters both the rights created and the ability to enforce them. That language is what creates a clear, enforceable legal duty. Without it, the statute begins to read as a general statement of policy rather than a binding prohibition. Civil rights laws traditionally work by pairing a defined right with an explicit ban on interference, allowing victims to bring suit when that prohibition is violated. Remove that prohibition, you create an immediate ambiguity about what conduct is actually actionable, giving defendants room to argue that no enforceable violation exists. Courts, in turn, are less likely to award damages, injunctions, or attorney's fees absent a clearly defined unlawful act, and they are generally reluctant to infer liability when the legislature has not spoken clearly, as the Supreme Court cautioned in Alexander versus Sandoval. Combined with the amendment's requirement that plaintiffs prove hostility, this change narrows the statute even further, restricting its reach while blurring its meaning. The result is a law that is weaker in force, uncertain in application, and far easier to evade, shifting it from a clear prohibition with consequences into something closer to an aspirational statement that bad actors can too easily work around. I will vote against this amendment.
Other people? Yes, Representative Tur. Oh, I'm sorry. I don't shoot you. Representative Tur. No, go ahead. That's fine. Thank you.
So I just wanted to say, I know that's not the motion that's on the table, but came into today thinking that this was in my mind, an ITL bill. I think from some of the testimony that we heard, there might be a couple of issues to be looked at, including Attorney Locke's offer to actually work toward finding some language that might address those. I think what I also heard was the issues that need to be addressed are fairly narrow and not necessarily the most likely things to be affected by the bill, but the implications of the way that this problem is being solved in both the bill and in the amendment are quite broad and can have significant implications for the ability to apply the protections that are there. So I guess what I'm saying is I would love the opportunity, rather than to vote ITL, to vote interim study on this bill, because I think there are some underlying issues that might be considered, but I don't think we should believe that the language that we're looking at right now is the only way to do that.
Representative Mannion and then Representative Smith.
Thank you, Mr. Chairman. You covered most of what I was going to say earlier. I just want to go over line 15 and 16, section 2 again. The fact that we heard the representative from the Attorney General's office, who is charged with civil rights violations, say there are two ways to look at this, indicates that that needs to be eliminated. Because which way are we going to look at it? As far as substantially motivated by hostility toward race, color, religion, national origin, ancestry, sexual orientation, etc., that currently exists in the criminal code under extended terms of imprisonment, RSA 651-6, I, and it's F. The exact same language is there when you're dealing with civil rights violations under the criminal code. And we heard my colleague say that this reduces the efficacy of civil rights. I see it more as strengthening our First Amendment rights. That's it. Thank you.
All right. Representative Smith.
Thank you, Mr. Chairman. I think I'm too old, and that's the problem. The fact that I worked on the Civil Rights Act of 64 and the Voting Rights Act of 65, and that I know that those were written not on a blank slate, not on tabula rasa. They were written in response to the world that we lived in, to the fact that there was clear discrimination that was not only tolerated, but expected, and that people in this country had to undergo that discrimination. What is past is prologue. We have to remember that we are living in an environment where we have had terrible discrimination, not only on the basis of race, but certainly on the basis of race. And then we go on to all the other areas that the vice chair so clearly mentioned. I have to say that I am shocked that after listening to the testimony, that the sponsor of the amendment didn't say, there is much that we have to think about that was presented by everyone who came here to testify, including, thank you very much, the representative of the Department of Justice, but not only the representative of the Department of Justice. These are people who have directly experienced problems. We're not talking here about the violation of the First Amendment. We're not talking about somebody shouting fire in a crowded auditorium. We're talking about real life experiences. And I would hope that the committee would vote down the amendment and would either vote down the bill or send it to interim study. This bill that is relative to civil rights enforcement is relative only because it's trying to make it harder to enforce civil rights, not to make it easier. And I can't be party to that. Thank you.
Representative Page.
Don't like to follow my colleague from Durham because won't carry any eloquence. And my English teachers from high school will tell you I was no Shakespearean scholar, but I think when that line was written, it was actually a compliment to lawyers about them. And it was sort of a suggestion that they let kill all the lawyers was actually a backhanded compliment because Shakespeare viewed lawyers as guardians of the law. And I think that context matters. And I think Representative Smith noted that with the context of our civil rights statutes and why they're there and what they're there for today, because all of those things exist, maybe more so. And I think it's telling that the Attorney General's deputy was here taking a position on that bill. And we had some back and forth about what that office does and doesn't do. I think as a guardian of the law, as a lawyer, he was saying that this position, this amendment and this bill would ultimately frustrate that context of which the civil rights statutes were come from. I think that's the alarm that he was saying. And so to me, that is a signal about what we're doing. And I think the woman who testified from Manchester asked us to reflect about that. And it's difficult for us sometimes to do that because we may have our own views already baked in. But I think when we do reflect on that, as others have said, we have heard pretty compelling testimony, and I dare say in the 6 years I've been here, probably some of the most compelling testimony I've heard, flashing a warning sign about what it is we're contemplating here to do. So I guess back to the Shakespearean reference, the context of this matters, and I think that's underscored by others who have said that. So I'll be voting against the amendment, against the bill. Thank you.
Representative Horton.
Well, I'm not a lawyer, but I'm concerned with some of lines 15 and 16 of your amendment, which crosses out a phrase, it shall be unlawful for any person to interfere or attempt to with the rights, because it seems to me that triggers two chapters of the RSA. I'm looking at it here on my phone in very small type, but there's a section 354B3 sets out the remedies, and you can get it's a civil matter if you're a victim, and then there's also section 354B4, which is criminal penalties that basically kick in if the civil remedy is not fulfilled. But it seems to me if we take those two lights out, that invalidates those two sections. So I don't like the whole principle behind it, but I think that's a fairly significant unforeseen consequence of passing this, to use one of the phrases we like here, unforeseen consequence. So I think that's another reason to vote against it, because I'm not sure how anybody would be able to get any of the remedies if there's no provision in the law for making it unlawful to violate the law. So thanks.
All right. Anyone else wish to be heard? Representative McFarland.
Thank you, Mr. Chairman. We heard today that a man of utterly odious views, Christopher Hood, was prosecuted not for a true threat and not for any completed unlawful act, but because officials from the DOJ disliked his speech and then layered onto it a chain of official speculation that they believed him to be a gun owner, that they believed that others would gather in Portsmouth, and that public safety therefore demanded action. And that is a very poor standard in a free state. It comes uncomfortably close to thought crime. And I concur wholeheartedly with my honorable colleagues that this language must be corrected.
Anyone else wish to be heard? Seeing none, all right, so the motion before us is my amendment 2026-1369. And so given the debate, I think we ought to have a roll call on the amendment also. So on the motion before us is whether to adopt amendment 2026-1369H, and I would ask the clerk to please call the roll.
Vice Chair Mannion,
Yes.
Rep. Mazer,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
No.
Rep. Page, Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron,
No.
Chairman Lynn.
Yes.
Motion passes 10-8.
All right, so we're now on to, hang on one second. All right, we're now on to the main motion, and I would move ought to pass on Senate Bill 464 ought to pass as amended with Amendment 1369. Is there a second?
I second.
All right, it's moved by myself, seconded by Representative Kutab. Anyone else wish to be heard on the main motion? Seeing none, I would ask the clerk to please call the roll.
Vice Chair Mannion,
Yes.
Rep. Mazer,
Yes.
Rep. Tripp,
Yes.
Rep. Andrews,
Yes.
Clerk votes yes. Rep. Perez,
Yes.
Rep. McFarland,
Yes.
Rep. Scully,
Yes.
Rep. Ball,
Yes.
Rep. Birch,
No.
Rep. Smith, Rep. Horrigan,
No.
Rep. Page,
No.
Rep. Manos,
No.
Rep. Turer,
No.
Rep. Rombo,
No.
Rep. Bergeron,
No.
Chairman Lynn.
Yes.
Motion passes 10-8.
All right. I will write the majority report. Who will write the minority report? Representative Birch will write the minority.
What will be the
And I
minority
assume that will
motion?
be ITL?
ITO.
All right. ITL. All right. All right. In light of that, I think we're done. Thank you, everyone. Representative Locke, Attorney General Locke, can I speak you for just a second? Yeah, we're done.